Insurance companies like to take the easy way out when they accept responsibility for an injury.
And what I see a lot of the time is the insurance carriers will never take that into account to try to reduce the risk that they have in terms of payment in the future.
So that needs to be addressed. And the legislation has been very slow to take that on.
All right, Jeff, let's start with the first question. Why don't you describe the litigation process in a workers' compensation case?
So Jason, in a workers' compensation case, there's different ways the process can be started. If you want to talk about petition practice, if somebody's case has been denied, we would file a claim petition on their behalf. And what that means is we're going to workers' compensation court and litigating a case in front of a judge to prove that our client has a work-related injury that they suffered in the course of their employment. And because of that, they either need medical treatment or they're losing time or money from work or both. And there's an evidentiary hearing in front of a judge. The other side gets to put on their defense and cross-examine our client. And ultimately, evidence is taken and the judge would decide the case. That process takes about 14 months.
And just a follow-up question to that, Jeff. In terms of where you live in the state, can the process take longer or shorter, just depending on what part of the state you're in?
Generally, yes. In the eastern region, let's say from Harrisburg over, it's roughly 14 months. In the western part of the state, they tend to be a little faster because their caseloads are a little smaller than the judges in central and east.
So now I want to get into the petition process and what the different petitions are. So what is a claim petition?
So a claim petition is where one of our clients has had their case denied, and we are seeking to start benefits for the client. We're making a claim against the workers' comp insurance company and the employer. And we have the burden of proving that there was an injury, that our client needs medical care, and that they're losing time or money from work so that we can get their benefits started when we win.
What about a reinstatement petition? Can you briefly describe that?
So let's say somebody has a workers' compensation case, they've been out of work for a while, they go back to work, and they're either working with a loss of earnings and getting a partial disability benefit, or they're not getting any workers' compensation wage loss benefit because they're making what they used to before they got hurt. But then something happens. The employer can't accommodate the light duty restriction, or their injury that they had worsens and they can't lift the parcels that they used to lift. They would come to us and we would file a reinstatement petition to get their benefits reinstated, started up again. Easiest way to think about it.
Now, how about a petition to review in the context of wage loss and then in the context of medical?
Insurance companies like to take the easy way out when they accept responsibility for an injury. Let's say you hurt your low back at work and they call it a strain or a sprain, but it's really a herniated disc or something more serious than a strained sprain. We would file a review petition with the court to review the description of injury, to upgrade the description of injury to make it more in line with the truth, actually. Because you know insurance companies as well as I do, they don't like to take responsibility for the big injury up front.
So, Jeff, a lot of the times when clients come to us, they don't have an understanding of why they're getting paid the amount that they are. And we explain to them what an average weekly wage is, but if they're already getting paid, what is the remedy to try to change that to more accurately reflect what they made while they were working?
All right, so let's get our terminology down. If somebody is receiving workers' compensation benefits because they're not working, that's called temporary total disability. We refer to it as TTD. So let's do that for the purposes of our conversation. TTD is based on your average weekly wage. And although you would think that average weekly wage just means all the money that you earn divided by how long you work there, it's not the case. Average weekly wage is a really technical concept. And you and I, who are lawyers, we know that we struggle with math sometimes, but we have to do it. We get all the wage data. we plug it into the formula, we apply the law to it, and oftentimes the insurance company has undercalculated the average weekly wage, the AWW, and therefore they're paying our client the wrong disability rate, the wrong TTD rate. And we have to remember that workers' comp is generally tax free. We're not tax lawyers, but there's really no tax on your disability rate. So if they're paying our client, if they're underpaying our client, we would go to court and we would present the mathematical data to the judge, and the judge, and obviously the other side, would make whatever argument they have about the math or the law, and then it would be up to the judge to decide whether we've calculated the average weekly wage properly and applied the law to the calculations properly.
There's a lot of times when our clients have two jobs. Sometimes they're working concurrent employment. And what I see a lot of the time is the insurance carriers will never take that into account to try to reduce the risk that they have in terms of payment in the future. So for everybody that's listening to this, it's important to keep your pay stubs both from the job that you got hurt at and any other jobs you had where you were on payroll. The exception is if you're an independent contractor and you're not considered a W-2 employee, those wages may not count towards your average weekly wage. So there are some intricacies that are important, and a lot of times clients don't realize that and try to litigate themselves, and they'll be at a disadvantage. So it's important to always keep your pay stubs in check. If you work a second job, keep those pay stubs as well, and really rely on a lawyer to get the biggest advantage you can in terms of what you're getting in checks every week or every 2 weeks.
Sorry for stepping on your toes. That's a really good point, because for those of you out there and for our clients, if you're working two jobs, you get to add the two average weekly wages together, which really jacks up the disability rate that you could be getting. So let's say you're working a part-time, heavy-duty job and you're making minimum wage there, but it prevents you from working your other job. You add the wages from both, and your disability rate is based on both jobs, even though you were only hurt at one.
Now, a lot of the time, people ask questions. Well, do we have to testify live before a judge? Do we have to go into court? Do we do it over a Zoom or a Microsoft Teams? And one of the ways that we explain how they present their case is through a deposition. So can you explain what a deposition is in terms of how the claimant participates or the injured worker, and then how other lay witnesses or doctors also utilize the concept of a deposition?
Absolutely. And I think for another podcast, we should really go into how we prepare for a deposition and how we prepare our witnesses for a deposition. But a deposition is just like being in court. There's a court reporter there. You're sworn under oath to tell the truth. And we present our side of the case by asking you questions that we have spent time preparing with you, so that we tell your story in a question and answer form. A court reporter takes it all down, and it's printed up into a booklet that is eventually given to the judge when the judge goes to decide the case. Every judge sees the client in person, either live or by video, before they decide the case, but a deposition sort of kicks it off. The way we take our medical testimony is the same way. We take a doctor's deposition and we meet with the doctor to ask them questions about your case and get their opinion on the record so that we can present that to the judge. And the other side is there to cross-examine both you and the doctor to try to poke holes in the case.
The way I usually explain depositions or even testimony live in court to our clients are, we are drafting questions to allow you to tell a story that is the easiest way for a judge to understand what's going on. And the only thing we ask is that you tell the truth. I think a lot of clients come in with this misconception because they've watched something on television like Suits or one of these shows that really doesn't reflect how a lawyer litigates a case. but it's simple in the sense that we only ask you to tell the truth and we frame it in the way that it's a story so you can convey it to everybody involved in the case.
That's a great way to think about it. TV shows and movies have really done a disservice to what people not in the business perceive to be how courtrooms are run. Not like that at all. And you're right. Everybody has a story. We're just here to tell their story.
So the next topic that I want to talk about is mediation. And before I ask you the question, I want to give a nod out to you. When I was practicing before you, when you were a workers' compensation judge, there was nobody better in the state than you at mediating and settling cases. So for everybody that's listening to this podcast, you are literally hearing advice from the top mediating judge in the state for about 15 years. And we're lucky enough to have Jeff, who is our managing partner, explain this to you because inevitably, everybody always asks, what is my case worth? So let's get into the mediation process. How is it set up and what impact can it have on an injured worker?
I love mediation. I loved it as a judge, and I love it as a practicing attorney representing injured workers. A mediation, at the end of the day, takes the risk out of litigation. It gives the parties closure, it gives them satisfaction, it gives them peace of mind, and it lets them move on with their life. A mediation can be very, very easy. It can be very complicated, but basically it is paying a lump sum of money for the disability benefits that a person is or may be entitled to, medical treatment, and it's wrapping it all up into one package and closing out the case. It takes a lot of work to prepare for a mediation, and it takes a lot of sophistication to negotiate a case. One of the things that our clients often need reminding about is in workers' compensation, sadly, there is no pain and suffering. Workers' comp doesn't pay for the agony that you can't do the things that you used to do, and it doesn't pay for the pain that you wake up with in the morning and that you go to bed with at night. Workers' compensation is very dollars and dates focused, medical treatment, loss of time from work. But a good lawyer can really package that into a compelling story and turn it into a really satisfying result for their client. That's the mediation. That's the idea behind mediation.
Right. And a lot of the times in litigation that drags out over 18 months, especially in denied cases when injured workers are sort of starved by the insurance carrier, not getting what they're entitled to, mediations act as this closure, meaning that you get paid that lump sum and you're able to move on with your life, which is an important concept. So mediations are eventful in a number of ways. It brings closure to your case, but it also balances that sort of scale for everybody that's been suffering for so long to get a lump sum to be able to move on with their case.
I think that we should have a whole separate conversation about mediation because it is really big. It's really important. But just for our listeners, just so you know what a mediation is when a judge who doesn't have any interest in how the case turns out. It's not the trial judge that we're litigating in front of. It's another judge that we asked to help the parties craft a resolution. The mediating judge becomes the clearinghouse and the neutral party in the room so that you can go to the mediating judge and say, Judge, here are the strengths of my case, here are the weaknesses of my case that I don't want the other side to know. And the other side saying the same thing to the judge, and that mediating judge takes the strengths and the weaknesses and brings both sides together. That's the art form of a mediation. That's generally how they're conducted. But again, you and I could talk for an hour just about mediation, and I think we should.
We'll do a follow-up with regard to that because that's a really important point. The next one, I love this question. It's why hire a Krasno attorney? And I want to take this first. And I want to go back to when I was a kid, watching my father and grandfather sitting at the kitchen table, talking about cases passionately for hours upon hours upon hours. And I stress the word passionately because for 3 generations, the only thing we've done is represent injured workers. So whether you are a father, whether you are a grandfather, whether you are a son or a daughter, we have represented generations of families that continue to trust us to act in their best interests. We don't treat our clients as a number. We don't treat our clients as a blank check. We treat you as a human being. We treat you as part of the Krasno family. We've been doing this since 1936, and over 90 years, we have gotten really, really good at knowing what's best for the client, but also listening to your questions, listening to your concerns, and trying to bring the case to light in a way that is best for you. So hiring a Krasno lawyer doesn't mean you're just hiring a lawyer. It means you're hiring an extension of your family to protect you and to help you through the litigation process. Now, knowing us, Jeff, since I've been a lawyer, since you've been practicing law, what's the difference between a Krasno attorney and other attorneys that you've seen?
So, Jason, it's hard to expound on what you just said, but there are some thoughts I have. I had tried cases in front of your grandfather when he was a judge. I had cases against your dad when I was doing defense work. And when I became a judge, both you and your dad litigated cases in front of me. And when I decided to leave the bench, as the expression goes, I could have gone anywhere, but I chose Krasno. And I chose Krasno for the reasons that you said and more. The Krasno attorneys were always prepared, professional, polite, efficient, and there was always a clear recognition that they knew their clients and that they knew their client's case and that there was a warmth in the courtroom when they were representing a client. Additionally, it is clear to me that the Krasno firm then and now doesn't look at the client as a cash machine. If somebody can get better and get back to work and be productive, that's okay. But if somebody isn't getting better, needs further medical care, and can't get back to work, there is no fiercer advocate than, I believe, the lawyers in this firm. And I think that says it all.
All right, moving on, we're going to talk about, I think, a really sensitive subject in workers' comp, and that's scarring claims. And for the longest time, scars were only allowed from the neck up. And I mean, we've been in practice for a long time. We've seen horrific and devastating scars from the neck down that were never compensable unless they were disabling. So can you talk about the evolution of scarring legislation from when we first started practicing law to where it's going?
Again, this might be a whole subset. I'll try to hit the high points. In workers' compensation, part of the Workers' Compensation Act awards benefits, a weekly benefit for a scar that is serious and permanent and disfiguring. And basically, it's permanent if you've had it for more than 6 months. And it has to be from the head, neck, and face. That's where a scar is compensable. If you have horrific burns or other scars on parts of your body, right now under the law, those are not compensable. You don't get anything for them. And we're going to come back to that. But if you look at the fairness behind the scarring awards, they're really not fair. If you are a model and you're starting out in the modeling industry and you get a scar from work and it ruins your career and you're not making any money because you're starting out, your scar is based on how much you earn. So if you're a fashion plate and you have a disfiguring scar and you're only making $100 a week because you're starting out, your award is going to be minuscule. Whereas if you're an old grizzled guy like me or you, and you get a scar and you're making more money than that, you could make more money from your scarring award just because you make more money in your job. So that needs to be addressed. And the legislation has been very slow to take that on, notwithstanding the lawyers pushing to make that happen. But there's presently a law moving through Pennsylvania legislature to allow scarring on other parts of the body and not just head, neck, and face, which is obviously a good thing. Another thing about scarring awards is typically they're not payable until they're not payable if you're receiving workers' comp, and the law is moving to change that as well, so you can collect both at the same time.
I remember my dad telling me a while ago when he was practicing that when someone had a scar on their face, he told them to put hemorrhoid cream on the scar to enhance it when they went to court because it would make it more visible. So I don't suggest doing that. I don't know from a dermatological standpoint whether that's the right advice, but it seemed to work when he was litigating cases back in the day. So
we should have a whole conversation about some of the letters that your dad would write. And when I was a judge, his mediation memos were literally the best. I talked about them at continuing legal education programs because of their pithiness.
I think that would make a good topic of conversation for the next time we sit down with these. The next topic I want to talk about is what to expect with your case. And I'll talk from my perspective first. So when I initiate a call with a new client, I think what's important to do is introduce yourself, which I think is a lost art amongst lawyers. They just get on the phone, Mr. and Mrs. Smith, this is so-and-so, tell me about your case, blah, blah, blah. I like to tell people who I am, why I'm here, the purpose that I'm serving, and then I ask them if they have any questions before we start. Because inevitably, it's a anxious process for a client to hire a lawyer. And people are thinking about, the initial call with the lawyer. They don't know how much it costs. They don't know what's going to go on. So I think a way of sort of disarming the client and relaxing the client is to say, before we start the process, what questions do you have that I could answer right now? And then go through what we typically do with lawyers. So once I'm done with answering their questions, I talk about doing a game plan for them. But first, I have to understand what the posture of their case is. Developing a game plan for me is, are they on comp or are they not on compensation? If they're not on compensation, what do we have to do to give them the best opportunity to be successful in their workers' compensation case? Are they treating with the company doctors, and are those company doctors supportive? If they're not, we have a vast network of medical doctors that we can get the clients into. And one of the important points, I think, about what to expect when you are represented by a Krasno, and Albedinjo lawyer are, our philosophy is that we're going to send you to doctors we would send family members or friends to. So we're not just sending you to any random doctor. We vet our doctors to make sure that they are the right medical practitioners for our clients. Once we get them into the doctors, once we get the answers we need with what's really wrong with them, then we initiate the litigation process, which you originally talked about. So for a client to ask the question of what to expect from a Krasno, and Albedinjo lawyer, you're talking to a friend that is vigorously going to fight for you and answer your questions and be available for you throughout the litigation process. And even when that litigation process ends, even when the case settles, we are always going to be there for you. If you ever have a legal question or a legal concern, we're there for you, whether it's beginning of the case, during the litigation, or after the case. You could always rely on us. That's what my expectation is for our clients when they hire us.
You know, Jason, I think you're absolutely right. I agree with you. I'd like to just add one thing. What strikes me about the lawyers here, and one of the reasons that I was so happy to join with you, is to a certain extent, I think we might all be frustrated teachers in the sense that we educate our clients every step of the way about what's coming around the corner, what's the next step, how do we deal with it, what are our strategies, what's in place if this happens, what's in place if that happens. There's a lot of thinking that goes on behind the scenes, and we convey that to our clients. We share that information with them. And I think that our clients can expect that as well.
We're really lucky to have you. So, no, we are. I still remember back in 2012 how excited my dad was when you're like, I'm looking for work. My dad was like, whatever it takes. So, yeah. This is a question that comes up a lot. I think there's no better lawyer in the state to answer this question. So it's a 3-part question. How do cases settle? What is a settlement? And what do they look like?
Are you answering that one?
No, I'm going to let it to the expert, the settlement team to be able to answer that question.
There are an infinite number of ways to settle a case, and it really depends on what the client needs. You can settle a case for cash on the barrelhead, medical and wages. You can settle a case for cash and physical therapy for 6 months, surgery, no surgery. You can get as creative as you want in how to settle a case. Now, of course, the other side has to agree to it, and that's where our negotiation skills come into play. But we can settle a case for whatever suits the client, whatever is best for the client. And now I forget the other 2 questions.
Sure. What is a settlement?
A settlement is usually a final deal that ends the case. However, if we are litigating, let's say, a claim petition, as we talked about earlier, somebody is trying to get their benefits started up, we might agree on what the person's disability rate is. The insurance company might agree that they have a strain that's keeping them out of work. So we can have a settlement, an agreement within the middle of the case to get benefits started up for a strain, get money coming into the household, and then we would litigate the rest of the case, that it's more than a strain, that it's a herniated disc or it's surgical or whatever. So settlements can be either a concluding deal that ends the whole case, or it can be an agreement along the way that advances the ball.
We're coming up on Halloween. The next topic is workers' comp horror stories. And it's unfortunate, but we have a ton of these. When you've been in practice for 90 years, you've pretty much seen everything that can transpire in a workers' compensation case. But there's always something that surprises us. So as a judge, I think you have a unique perspective on this, because as a judge, you've seen horror stories throughout your tenure. And I've been practicing for 26 years. I've seen my fair share as well. So as a judge, what is one of the horror stories that stands out for you? Then as a practicing lawyer, what is one of them?
You and I have both been in the business long enough to know that people go to work and start their shift and think it's going to be business as usual, a regular shift. And in the blink of an eye, terrible things can happen. And life-changing moments, and sometimes people don't come home from work. I know that's not a horror story. I mean, it is a horror story, but how people get injured is one thing. The most difficult horror story I had as a judge was a woman who was ejected from a vehicle during a car accident, and was largely a quadriplegic. And notwithstanding that, she did not have great representation and she didn't prevail in front of me. And that was the most difficult thing I've ever had to do as a judge. I don't know if she could have won if her representation was better, um, but she was underrepresented at the time.
This actually leads me to a really good point. I think we have handled some of the most complex and catastrophic injuries in the state of Pennsylvania, both cases that we get on our own that come to us, but as well as some very prominent personal injury firms that handle catastrophic injuries rely on us because we do our due diligence. We never, ever underrepresent someone. If we need 10 experts, we get 10 experts. If we have to investigate it for hours, we do that. But the one thing that I think can confidently say in the past 90 years, we have never, ever underrepresented someone. So I can imagine how hard that was to see as a judge.
You know, that was, I've been with the firm 13 years, and this was several years before that. I remember the witnesses, the testimony. It's one that I'm never going to shake, you know.
How about a case that you've had as a litigator with this firm that really shocks the conscience? Really, it was, and I want you to talk about it from how the insurance company acted given the extent of the injuries.
I'm going to have to think about that. I would kind of like to tell a somewhat happier story if I could for a moment. And then I'm going to throw that question back to you. I represent a young guy for about 5 years now. And he's one of the folks I was thinking about when I said their lives changed in an instant. He got his hand caught in a machine and had a terrible, terrible injury to his hand and developed very serious complications in his arm. And his girlfriend stuck with him. He went through many, many surgeries and is still having many issues and will need prosthetic devices for the rest of his life. He has since been engaged, gotten married, and had a baby. And I settled his case today. And he's ecstatic, and I am too for him. Some of these, you know, it just makes you feel good when you can really help somebody who really needs your help.
You know, I think one of the special things about our firm is that I know exactly who you're talking about. And you've represented this guy the entire time because we talk about our cases. We talk about our clients as if they're friends. So congratulations on that. I know exactly who you're talking about. Yeah. I'm going to bring up a case that I know you're very familiar with. It was in the news about 3 years ago. It was an EMT worker that was working with someone that wasn't trained, who drove an ambulance. And this individual didn't set the parking brake. And while the EMT was administering treatment, the ambulance rolled and crushed our client. She passed away from her injuries, and her mother, who was a dependent, and relied on that income from her daughter who was deceased. We had to litigate that case for a year and a half. The insurance company threw everything they possibly could, forcing the mother to pull tax records, utility records, and recount every single day how much her daughter meant to her, both personally, but also the relationship they had and the support that they had. And you talked about a case's value is dependent upon the income that that injured worker has. And as an EMT, the deceased did not make a ton of money, and the dependent in a death claim gets a portion of that income. And we were successful in that case after extensive litigation. And the toll it took on the mother, I will never forget, and I don't think you will either. But the award that came out of it was not enough. It would never be enough to make up for the loss of the daughter, but it was the award didn't even allow the mother to get out of the debt that she incurred when her daughter passed away. You know, workers' compensation is supposed to balance the scales or make the injured worker whole again. And it very rarely does that. I wouldn't wish a work injury on anyone because it disrupts your life. And there are certain circumstances where even that settlement, even that lump sum, isn't enough to replace the damage that's done. And these are horror stories that happen every day. There are death cases that happen every day. There are catastrophic injuries that happen every day where children lose a parent that will never be the same because of a traumatic head injury or an amputation or being a quadriplegic. So I don't want to focus on such negativity, but they are out there, and we are going to help you throughout the entire process, no matter how difficult it is. So, let's talk about some workers' comp success stories. Now, you just talked about the case that you settled today. What's another one that, well, there's a lot of them. So pick another one that you just smiled, so I know that you have.
Well, yeah, there are a lot of them. You know, that's some of these. We have clients that we're with for years and years and years, and sometimes it doesn't take that long to get their case over the finish line. And those are as rewarding because people really need that new lease on life. And when we're talking about settlements, that's what a settlement can do. I'm having a hard time coming up with one that sticks out in my mind at the moment.
I have one. So, you know, we represent a lot of people. We represent a lot of unions as well. And the one thing that we always tell our clients is the minute you get hurt, you report the injury, you get treatment, and you call us. Because if we're able to guide you from the very beginning, there is a higher likelihood that we can get your case accepted, and there's not going to be a drop off on wage loss or on medical benefits. So a good friend of mine got injured, called me immediately. We developed a game plan right away. He knew exactly what to tell the insurance carrier, provided the medical records that were needed. We guided him to a panel doctor that we knew would be fair with him. And he was out of work for a period of 2 years. But during that 2 years, his wage loss benefits never stopped. Medical benefits never got denied. He was able to get all the surgeries that he needed, including there was no other expert in the state other than one of the doctors we knew. We were able to get him in there, and he returned to work. He's working full duty. He's going to be able to allow his pension, his retirement, his 401k to vest. And this isn't some lump sum story that a lot of firms post on their website or on billboards. This is about doing the right thing, guiding a client through the process to get the absolute best result that they possibly could. That is a success story. just as much as the $1 million settlements that we get for our clients. We don't have to publicize those. We publicize the ones where we're doing the right thing for our clients, and they are forever grateful.
I think I'm familiar with that case that you described too. Nothing is more rewarding than getting a guy better, having him go back to work. He's making great money, contributing to his future. Yeah, it's a good feeling.
All right. The bane of our existence with surveillance and social media. So I have a very telling story about surveillance. You're familiar with this defense attorney. He is the devil reincarnated. And I had a client, I truly believe he is, but I had a client who had in the past been addicted to drugs. He recovered, he didn't have any relapses, he had a good job, and he gets injured at work. He goes to panel doctors that prescribe narcotics for him. He says, I can't take those. I can only take anti-inflammatories. And what usually happens with panel doctors, they release him early. We get him into doctors that prescribe him non-narcotic medication that helps him. While we're in litigation, he's taking his dog for a walk one day, and he notices two gentlemen follow him. He also notices a hidden camera, but doesn't say anything. And we had instructed him on that insurance companies can hire private investigators, can fly drones, but they can't come onto your property. And their goal is to try to catch you doing something you shouldn't be doing, or to make it appear like you're not disabled. If you forget to use your cane, or you're not using a boot, or you're dragging out a garbage can, they could film it in a way to manipulate it to make it look like you're not injured. So going back to this individual, he's taking a walk with his dog. These two gentlemen approach him and offer to sell him drugs. He takes a picture of one of the individuals, declines the offer, and continues to walk. I get the private investigator's report. I look up who the private investigators are, and it's one of the gentlemen that offered to sell him drugs. I call this defense attorney, and I want to keep this professional, and I want to keep it child-friendly. But I've never, ever in 26 years had someone go so low as to try to entrap one of our clients. And that's an extreme story of surveillance. What I tell clients with surveillance is they cannot trespass on your property, but they will sit in a car outside. They will wait for you to mow the lawn, or if you're going to shovel snow, which we don't recommend, especially with a back injury, they will try to get you to do some activity that goes against what your doctor told you you can't do. Social media, I think, is the bane of our existence. You know, social media is a way for people to demonstrate the most positive aspects of their life. They celebrate, in a lot of the pictures, they are on vacation, they are with family, they are with friends. It's very rare that you see someone who has an injury that's trying to present that in a social media platform, unless it's for a GoFundMe site, right? So for injured workers, it's really important to restrict your social media when you have a work injury, to not portray yourself in a way that your life isn't impacted by this workers' compensation case. And with regard to surveillance, follow your doctor's restrictions to a T. If you have to wear a boot, wear a boot. If you need to use a cane, use a cane. If you have carpal tunnel and you need to wear braces, wear those braces. Because the minute you don't follow those doctor's restrictions, there's going to be a private investigator that's going to take a video or a snapshot of you to use that against you.
I didn't know the one about the potential entrapment. That's brutal. Amazing. With social media, so you make great points about the surveillance. Surveillance can be deadly if if they catch you doing something that you shouldn't be doing. And let alone if you're working and not telling us, we'll fire you as a client if you're committing fraud. However, with social media, you can control your own conduct when it comes to surveillance. You're walking, you're lifting, it's up to you. With social media, you're at the mercy of whoever you may be friends with or connected to on social media. So if you're at an outing, at a game, at your child's game, at some sporting event, and somebody takes a picture of you enjoying yourself, depending on the context, it can come back and haunt you. So I recommend to my clients, you can't pull down information from social media if it's up there. I just say, stop posting. And please tell your friends and family, don't include you in group pictures. Don't create a situation that could look bad in front of a workers' compensation judge, because ultimately they're going to be deciding your fate, and you don't want to have to give them anything shoot you with. Yeah.
Next one is tips and tricks. What tips, what tricks do you recommend to clients when you first meet them, sort of help navigate through the muddy waters of litigation?
Can we save that for a whole nother segment?
Sure. I have a couple that I can give you right now. Whenever I talk to a client, I always tell them to save every email and to keep every piece of mail, including the envelopes. Because at some point, if a check is late and they still mail the checks, that post date will come into play. Or every email from an adjuster or from a nurse case manager may have some tidbit of information that could be helpful with our case that we can use against them. It is crucial to remain organized when you have a workers' compensation case, even though your life is turned upside down by this work injury. The more organized you are, the more that you save helps us get necessary information that can help us with the litigation. Some of the other tricks and tips that I recommend for people are, we've all had injuries, whether it's in childhood, high school, college, or if we enter the workforce early. And diagnostic studies like x-rays, MRIs, CAT scans show evidence that we've had these prior injuries. There is some type of evidence, whether it's scar tissue or a calcium deposit or something, to show that we've had prior injuries. So whenever I meet with a new client, I tell them to take a good hard look at their medical history and write everything down that they can remember. We have client care coordinators that follow up, that try to get all the doctors that they've seen. And in order for us to be really successful with a workers' compensation case, we need the entire medical picture. Which brings me to a really important point and a tip that I think all our lawyers do a good job of conveying to our clients, which is don't lie to us. Especially when it comes to medical, especially when it comes to the facts of the case, because there is evidence out there to contradict anything that you think you can hide from us. And that can completely derail a case. So those are my tips and tricks with regard to our clients.
Well, I can't let you have the last word. Picking up on what you said, take responsibility for your own recovery. Keep your doctor's appointments. Go to your doctor. Be compliant. We work really hard to advocate your medical case. Don't make our case harder by skipping appointments, not getting diagnostic studies. Take responsibility. That's number one. And Jace, I'm going to let you finish with the 3 don'ts. Those are the biggies.
Never quit, never resign, and never retire. If you voluntarily remove yourself from the workforce, you negate your ability to collect wage loss benefits. I can't tell you how many times we have signed up a new case and they said, well, we resigned or we quit because we didn't like what was going on. You are giving the insurance carrier, you are giving the employer an absolute gift that is gift wrapped and ready to serve. Never, ever quit, resign, or retire. Always talk to a lawyer before you decide to do that.
Thank you. Music to my ears.